Here we are right at the front end of summer. Families are making decisions to send their kids away to camp. We entrust our children to these camp people. Well, what do we really know about them? What can go wrong? What can families do to be proactive to make things safer? To be vigilant about protecting their children, whether you're a dad or a grandfather. I mean, this stuff is very real. Our tagline for our firm is righting the heaviest wrongs because we do feel very strongly that we use the legal system and tort law to address a lot of social problems, to try to obtain justice for our clients. And we're hopefully addressing what we know are your concerns. Recently, a little boy was raped at a summer camp. And the story of how that happened is chilling. It speaks volumes about what should not have occurred. But here we are at the front end of summer, and we feel that for somebody looking over what occurred to this poor child has created a platform for educating the public, educating parents who are going to be sending their kids to summer camp or entrusting them to these people who claim to know what they're doing by way of mixing children of different ages and different backgrounds to keep your child safe. And so to that end, Brad will tell us about a verdict that we just obtained, a very significant verdict, $49 million in compensatory damages and $1 million in punitive damages for the rape of a child that was predictable, preventable, and if the parents had been told truthfully about the capacity of the camp, they would have entrusted their child to this camp. They never would have allowed their child to be at this camp. And so, maybe Brad, if you could tell us all a little bit of background about the case.
The lawsuit that we're here to talk about was a climbing gym. It was an indoor rock climbing facility. It wasn't a camp. It was a rock climbing gym that ran a business as a rock climbing gym. And the evidence in the case demonstrated that what they tried to do is to try to drum up business to get people in the doors. And the way that they decided to do that is to open a camp as a secondary business to the already established business of a climbing center. And what they did is they began advertising on social media and trying to get families to trust the known business of the climbing camp under the guise of it being an established summer camp. There was no summer camp ever set up. This was the first of its kind at this location. They had no rules, they had no policies, they had no procedures, they had no management. They had no real plan of how they were going to run the camp. The very first step they did was to try to figure out how to get people in the door and pay money. And then they tried to figure out how to set up a system afterwards. What we were able to learn is that about February, about 5 or 6 months before the incident happened, the corporate structure up in Chicago came up with this idea that they're going to drum up business by having social media advertisements to try to get people to come. And they did. They actually set it up and filled out online forms, created forums, and the families were able to see the advertisements. They actually even did an interview on the local news and promoted the summer camp. The problem is they were a climbing gym, not a camp. They had no industry standards. There was no policies, no procedures. There was no rules. In fact, they never even had a staff member who had ever run a camp before at the facility. They get about 16 kids that came in and paid money to be supervised. And the problem is, on the day of our incident, the manager went on vacation and was out of town out in the mountains out west. And the assistant manager left to go to the dentist office and never came back to work that day. So essentially, the entire staff from the management standpoint was gone and out of town. And they were left with 3 college-age kids that were in charge of watching 16 children under their supervision. The facts of the case showed that the kids kind of wandered throughout the day without any real supervision at all. There were surveillance videos of the incident, and you could see where the camp counselors were, where the children were. And throughout the day, the kids actually freely went in and out of the bathroom without any type of supervision or any type of safety system. Established camps end up having rules and policies, procedures of how children are allowed to use the bathroom and what supervision is allowed throughout the day. This camp had absolutely no rules. In fact, one of the campers, a 13-year-old boy, had prior warning that he had some misconduct that was known to the family, and the family warned the camp that the boy, a 13-year-old boy, was not allowed to go in the bathroom alone, unsupervised, without any type of camp counselor assistance. This rule was misinterpreted by the climbing facility, and they allowed this boy to go into the bathroom alone with two different children. There was an attempted sexual assault on a 5-year-old, and there was a successful, unfortunate criminal act that was conducted by the assailant of sexual assault that took place over about a 30-minute time frame in the bathroom, with not a single camp counselor recognizing that this boy had left or that any of the other children had left. There were 3 children that were completely unsupervised for more than 50 minutes. We tried to figure out how the failure happened, and it really became clear that this was a corporate scheme or plan to get money into the company. They actually had a corporate facility up in the Chicago area that was taking all of the intake business online. So all of the intakes were coming in to the Chicago office, and there was absolutely zero communication between Chicago and the Peoria office. So none of the people down in Peoria, the management, nor any of the camp counselors knew any of the written restrictions that the mother had sent in to the camp ahead of time. The mom sent in the restrictions thinking that the camp would honor the restrictions, would recognize them, and would take precautions. But there was a complete and total breakdown of communication between corporate and the Peoria local office, such that Peoria didn't even know of the restrictions. So when the mom came to camp on the first day, she followed up to tell the facility, the climbing facility, that this boy needed special supervision. She did that with the assumption that the camp knew full well what she put on her intake form, that this boy needed firm limits, was impulsive, and needed lots of supervision. None of that was relayed. The mom came in, gave additional information that he was not allowed to go in the bathroom unsupervised. And through a game of telephone, none of the camp counselors were able to figure out the reason why this restriction was needed. The evidence in the case was kind of all over the place from the camp. Some of the camp counselors thought that the boy wasn't allowed in the bathroom for his own safety because he had been bullied in the past. The problem with that is that the camp had been with this boy for over a week, and they knew that he wasn't ever bullied by anyone in camp. In fact, the overwhelming evidence is that he was the one who was bullying everyone else. So
Wasn't he the biggest kid in the camp?
yeah, oh yeah, he was 13, and the camp went down to as small as 5 years old. The boy who ended up being the criminal assailant in our incident was the biggest boy, strongest boy, and the one that was known in the camp as the bully. The camp counselors assumed he had been bullied in the past, and therefore thought it was okay to just let him go to the bathroom alone because they didn't think he was at any risk of being bullied, since he was the one who was bullying other people.
So Brad, what for a family that's, I'm a father of a grandfather, a father of a beautiful daughter, now has 2 lovely sons, and they're 4 and 7. They want to go to camp. What kind of questions should families be asking of the camp operators?
I think the first thing that you want to do as a parent, if you're looking into putting your kids into camp, is that you should find an established camp that has been around for a long period of time. The reason for that is it's going to have the framework or infrastructure necessary to be able to run smoothly from a management standpoint, from a policies standpoint, from a procedure standpoint. Further from there, I also think that when camps are established for a long time, they can be certified by a number of different camp organizations. There's industry standards that are followed. And I think one really good question that a parent could ask to a camp is, what industry standards does the camp follow when it comes to supervision? And I think right there, the answer that you get will be entirely clear to the parent about whether or not it's a fly-by-night camp that has no real rules and they're literally doing it for revenue, or if they have a legitimate purpose and a legitimate framework.
So I think there are certain, if we look at what I said at the beginning, responsibility, accountability, and legacy. Tell us about the jury verdict itself and what the jury had to assess and what kind of accountability did they establish?
The legacy of the case from a long-term perspective is certainly going to be one that stands for the proposition that reasonable restrictions have to be honored by a camp. If a parent comes in and has a reasonable restriction and asks the camp to follow a rule of safety for their child, that if a camp chooses not to follow it, or even worse, ignores the basic safety rule, that there's heavy ramifications for doing so. The jury, in this case, provided full compensation on the compensatory claim, but then had $1 million in punitive damages. The $1 million of punitive damages were sending a message to other camps out there to make sure that this same type of conduct doesn't happen at all, ever, in any other camp. And I think that's kind of what the verdict's going to stand for, is that this lack of supervision is not something that could be tolerated.
If I go to a camp and I say, okay, I want to enroll my child, at this facility, did they have information about the credentials or the training or the background of the people who were operating the camp, or none of that at all?
I think that a good camp, a camp that I'd be safe sending my kids to, would be one that would have at least the background and some of the resume or credentials for the people that were in charge, the management of the camp, the people that were the higher ups, that were the ones that were in charge of supervising some of the camp counselors. I think all too often you're going to get camp counselors that are younger kids. You're going to get people that are in college. You're going to get older high school students, and they're going to be the boots on the ground, day-to-day kids providing supervision. And I think that's just the nature of camps. What I think you have to be on the lookout for is if there is a management structure above them, because the kids get into it for good reasons. The young college kids are out trying to have a summer job, and they're trying to do good, and they're trying to play and connect with the children. And I think that traditionally they go to work trying to do the very best job they can. The problem is if the people that are in charge of the college students that are supposed to be the boots on the ground aren't there managing the kids, aren't there supervising the kids and giving them a framework to operate on, there's really going to be no safeguards to make sure that basic safety rules are followed. And that's really the main thing I would look at.
So even with all these municipal camps, we're from Chicago, in all this, both in Chicago and the surrounding suburbs, the municipalities run public pools, public camps. Shouldn't there be, and aren't there certification programs that establish minimum training that the people who operate and work at these places should receive?
There definitely are lots of municipal camps that are out there. Over the years, we've handled other camp cases. In fact, we had
Years ago, we had a drowning case.
We had a drowning case.
Tell us about that.
We had a drowning case involving a local public entity, a South Suburban park district that had a summer camp. And the summer camp was a great summer camp. It really had a terrific program with great policies, great procedures, and it was a great setup. And the camp ran terrifically every day. The problem that turned out is that, again, it wasn't the everyday activities of camp. It was the one day that they ended up having pool day. So this is a summer camp that's all summer long. And one of the days there was a pool day. And the kids who were in charge there were trained to do the daily summer programs. They had supervision of how to do daily summer programs, and they did an okay job there. The problem happened is when the environment changed and they went to a pool, which is a completely different animal than being at, the local gym or the local field house. They went to a pool and they didn't have pool safety. They didn't have pool safety restrictions.
They didn't train them.
They didn't train him at all. And we ended up having a little boy who didn't know how to swim, who failed the swim test, and he was allowed to go in water over his head without any type of flotation device. And in that circumstance, again, they lost track of the boy and he was allowed to drown without any type of safeguards because you have a camp that decided to kind of branch out and do something that they didn't have expertise. And I really think that that has been the common thread over the years of where these camps have gotten themselves into trouble.
Well, I mean, I walked away from that one believing that the moral of the story was that, as parents, we have an affirmative obligation. I mean, we're entrusting our kids, but we do have an affirmative obligation to inquire about the abilities and training and the skill sets that of the people that are running these things. And so there is an argument that the defense tries to make in these cases that this is on the parents. The parents didn't do their due diligence. And, we can fight about that all day long. I think those things are fact specific, but clearly the lessons to be learned to me from these things are that if you're going to entrust your children to a given camp, whether they operate just gyms or they operate climbing walls or pools, you need to pull the curtain back a bit and learn a little bit more about their capacity to handle your children. What training do they have? What skill sets do they bring? These are the things that are important because these terrible things do happen. And one common thing that we have always seen is that when these terrible things occur, there's always some failure that on the face of it, if you had known about it ahead of time, you would not have allowed it to exist. You would not have allowed your child to go into a swimming pool with camp counselors who have no training in water safety, who have no ability to put proper safety devices, or whether it's a life jacket or floaties on your child. And that's sort of the parents want to know those things, and you're entitled to know those things of how they're going to operate it. Just like if they're teaching your kid how to play basketball, you want to make sure that the teacher on basketball knows a little bit about the game. Well, it's the same thing here with these things that can go awry in terms of safety.
Illinois actually has a special duty. There's a special duty for summer camps to exercise ordinary care for the safety of the children, which is not necessarily a duty that comes out of common law, but it's something called in loco parentis. You're basically have the duty of the parents. The camp is stepping in the shoes of the parent at the time that they accept responsibility and custody of the child, and they are actually taking on the responsibility of being the parent, and therefore have a duty and obligation to protect and keep the children safe while they're at camp. The jury specifically deliberated for 2 hours, but they had a number of different questions. It wasn't just whether or not the camp messed up, because I think that was entirely clear to the jury by the end of the trial that the camp messed up. The jury had a couple different questions it had to decide in the time frame, which was about 2 hours. They had to decide, number one, was the camp negligent? And they had a unanimous verdict of 12-0 that the camp was negligent. And I think the evidence proved it very remarkably that there was just no question that there was negligence. The next question they addressed is whether or not there was what's called willful and wanton misconduct, if the camp demonstrated a conscious disregard for the safety of their campers. And the jury unanimously found 12-0 that there was a conscious disregard for the safety. And then from there, they had to address the topic of damages. And there were 5 different line items of damage that the jury had to decide unanimously before it could render a verdict. The verdict came back about 2 hours and 10 minutes, 2 hours and 15 minutes after the jury was instructed, and they brought back a verdict of $49 million of compensatory damages. Since the jury answered the willful and wanton question, the conscious disregard question, in the affirmative, saying that there was a conscious disregard, we then had closing arguments seeking punitive damages that came immediately after that verdict. About 3:45 on the night of the verdict, about 3:45, those arguments lasted only about a half hour, and then the jury retired again to deliberate on punitive damages, which took about another hour and 15 minutes, plus or minus, for them to bring back a award of punitive damages of $1 million.
And the thing about the punitive award, the expectation was the message the jury was trying to send, and their expectation of sending that message is that uh, the word certainly has spread in the corporate camp business. That Look at what happened in Chicago. These are the kind of things that can take place if we're not doing our job. These are the kind of things that will put us out of business if we're not doing our job. I should mention, yes, there's insurance, but the insurance, it's always a good question to ask what kind of insurance is placed on this facility. You're entitled to know that. But the entire verdict there's a fight. There will be a fight with the insurance company over whether they want to challenge covering this verdict or not. But the message has gone around to camps around the country that this is the type of terrible thing that can happen in your camp if you're not properly doing your work and your job. And this is the kind of consequence, the corporate accountability that can be assessed by an independent jury. And that's the beauty of the tort system, is not only does the tort system recognize establishing responsibility for the individual, giving accountability in terms of proper compensation for that individual, but the legacy part of this, spreading the word that these kind of things do occur, and there will be that you're going to have to be accountable, and there will be a day of reckoning if, in fact, you don't do your job the right way and you allow children to be abused on your watch. That in loco parentis doctrine that Brad mentioned is very real, and it's very alive all over the country, and certainly is there to protect our children.
When we talk about righting the heaviest wrongs, since the day of the verdict, we've gotten a number of different calls from people asking for help in similar circumstances. This isn't an isolated incident. We get calls all the time for people that have had injuries at camps and situations where people are hurt. And I think that at the end of the day, a child's innocence is taken away every time they're sexually assaulted. I think the verdict tells us that the compensation that was awarded by the verdict by the jury tells us one thing, that in the eyes of 12 citizens of Cook County, there's not much worse that could happen to a child than for them to be the victim of sexual assault. And when we talk about righting the heaviest wrongs, this is right up there as one of the worst things that could happen to a young child that will stick with them for the rest of their life.
That mantra of righting the heaviest wrongs fits into basically two things that I think we do. Certainly, as I said earlier and have repeatedly said throughout the years, you can't undo what was done. No amount of money can replace some of the losses that have been experienced by people. But certainly, just because something is priceless doesn't make it worthless. In our system of democracy, with the right to trial by jury, people on a jury, the 12 people who sit on a jury here in Illinois, have a sense of what the community thinks is right by way of a result to enter a just result under the circumstances for the claimant that's there. The second part of that verdict is the legacy that it provides to hopefully create a safer environment for someone else. For those who know our work in aviation, I talk frequently about graveyard engineering. Every airplane disaster that I've ever been exposed to has resulted in some change, some safety improvement that has followed the tragedy of loss of life associated with the crash of an airplane. Same is true for most product liability. I mean, just your vehicles today are safer because someone died. You have seatbelts because someone didn't. You have airbags because someone didn't. You have crashworthiness improvements in your vehicle because other folks died. This concept of legacy is important and meaningful, and we really hope, and I know our client hopes, the word will go out about it And if one child is spared this lifetime loss of innocence simply because of a parent asked better questions at the front end of signing up for a camp, that's meaningful to our clients. That's a meaningful result of what the law can do to right one of the heaviest wrongs ever.